Absent with cause.
Keith Kyle,
Here.
Christopher Allman,
Here.
Joseph Paglia,
Here.
Anthony Brunetti,
Here.
James Manning.
Here.
Mr. Chairman, you have 6 members
Thank you.
present.
All right, so the first item we have this evening is a public hearing. It's Mr. McGrath. It's located at 10 Spring Cove Road. Mr. McGrath, you have the floor, sir. Just for purposes, Chris, myself, Alan, and Keith heard the first portion of this, so we'll be the 4 that are voting.
Thank you.
Go ahead, Mr. McGrath.
All right, so since we met last time, I went over and remeasured and was trying to play around with it. I can now, I'll go back to 20 feet, and if I could go over to the flat part of the garage, which would alleviate the problem I'm looking to avoid with in the future with all the debris and the snow and everything building up in the middle, which, again, like I said previously, it rotted that
Right.
part of the house out, the garage, and I do have a picture of just snow in the garage. If I can attach the deck to that garage and the house, it would avoid that gap that was there. If I can move it over and attach that, I can leave it at 20. I know I was proposing a 14 by 22. I'll leave it at the 20, which will give me enough room on the end of the sliding door for the railing and the post coming out of the house.
So you'll be able to access
Yes.
the, so is
Yes.
the, when you're comfortable with the letter that
Yes.
Mr. McGrath brought, so
Yep.
that's excellent, okay. So, Mr. McGrath, is the deck gonna be the same size? Are you proposing the same size as before, plus the addition to touch the garage, to get to the garage?
I'm gonna narrow it down to 20.
Yep,
If I can, I'm still proposing the 14, which would bring it to the end here. And I'm just looking to cover up this gap.
That
And again, this is where all the debris would be and, the rot, and
right.
so I'm just, like I said, I can move it over, if I can attach it there, if I can move it over that couple of feet, I can leave it at the 20. I'm still seeking if I can go to 14 to cover the, over the door. There's a door like, like right here, and that was always a problem too, and I'm just
Right.
trying to, kind of hoping to cover so I can just seal everything up and not have to worry about any more water damage, any kind of damage.
And if you don't put the deck there, there's like a 15-foot drop off to the ground right there, right?
No.
If you don't
Where?
put it, if you don't put
Well-
the deck where you're proposing.
Oh, if I don't put it here?
Right. I mean, you just step out, there's nothing.
No,
there's
there's
there.
nothing, no. No, it's, yeah.
It's a substantial drop.
12 foot, yeah.
What are the current dimensions? Obviously, it's been taken down. What were the prior dimensions?
10 by 20,
10 by 20.
yes.
And so, and your proposal is a 14 by 20?
Yes.
Okay. Joe, what does that do as far as relief? How does that change?
It reduces the relief requested.
Did we look at, is that looked at?
No, I just heard about the change
Oh,
tonight.
okay.
I literally just playing around when I got back. I went away to my brother's birthday down in Virginia. I flew back yesterday.
Oh, okay.
And I came up and started playing around and trying to come up with something.
It does reduce the relief.
Jill, the use variance standard is still applicable, though you went with the reduction, is that right?
Yes. It's I provided some math to you. The reason Mr. McGrath's lot is being measured at a 20% lot coverage. It's a substandard lot, but it's essentially a pie-shaped lot. And because of its wide frontage and its wide width, it in zoning code, it brings the reduction, it reduces the lot coverage to 20%. A lot of this size, it's a 10,000 square foot lot, it would normally have a 25% lot coverage. But for the fact that it's an R20 zone and the width of it is so wide at the front, even though it narrows towards the back, under the modified dimensional regulations, it doesn't benefit him because the lot is so wide at the front.
So, Mr. McGrath, you didn't construct this original deck, correct?
No,
It was,
it was there when I.
when you
purchased the
bought
house.
the property, it was there, so. Obviously, the hardship's not self-created, so. I see you doing math over there, Jill.
I am. It's a 28 square foot reduction,
Mm-hmm.
so it would bring it down to, I haven't done all the math, Mr. Chairman.
That's all right.
It would bring it down to 481 square feet or a 5.8% lot coverage variance.
481.
Correct.
Okay.
Did you say 5.8?
I did. 5.8.
That's at the 20%, right?
That's
what
at
it is now.
20% with the reduction of the deck as you're proposing.
And Mr. McGrath, can you explain again, I'm sorry,
Sure.
why you need the extra 4 feet?
I'm simply just trying to cover this section.
That's where the leaves and everything.
Yes, the original deck, there was a gap of about 1.5 foot, and just everything piled in there, and like this section of the house, the lower level here had to be replaced, and this all had to be replaced, just from everything getting in that corner and just kind of sitting there and building up, and that's why I was hoping if I could attach the deck here. Besides just the safety end of it, it'll be attached to 2 points. I just feel it'll be much stronger with the winds and all. I'd like to cover this up, and I was gonna put one of those systems underneath the deck to keep it dry and just keep everything out of there, so I don't have to down the road deal with rot
And you
issues again.
need all of the 4 feet in order to do that?
Well,
Well, if I could, there's a door that's in again, this is how the house is, it was very.
Yeah, I'm trying to
everything was
remember,
out
I'm
of
trying to
bounds.
remember your testimony from the last
Yeah,
time.
there's a door that's like right,
Yeah.
it's kind of a few feet, it's almost 4 feet off that back wall. And if I did pull the deck over and leave it as it was, it would be
In the middle of the door.
in the middle or 3/4 of the door, it'd still be exposed, and I'm just trying to keep it from getting damaged. And
Understood.
do you have the floor plan?
Yeah, right here, Chris. He's trying to get rid of that,
So,
which makes sense.
fill in this area, which obviously makes sense to me. But the additional, did you say there is a door here?
yes,
There is?
yes, sir.
Okay. And that accesses,
That back room, underneath in the garage, the back part of the garage.
okay. And how do you access that now?
The garage,
The,
that door,
yes,
well, either from coming out from the backyard, or I go through the house into the garage and then out that door to the back.
all right. But is that door on the same level as these doors? No,
No,
that's on the ground.
that's on the ground floor, yes.
Okay. So the
Yeah,
reason,
this is up higher.
right, this is elevated.
Yes, that's correct.
So your reasoning for adding, so you want to add 4 feet along the 22?
No.
You go, you want
Well,
to,
the 14,
yep,
yeah, originally this was the 10 going.
10, but you want to
Yes.
bump it out to 14 to
Yes,
cover
this I'm
that
gonna,
door?
that I'm gonna leave it at 22, because that'll leave me enough by the sliding door for the railing and.
Right,
and
no, I
posts.
understand that. It's just that 4 feet, I was,
Kind of squares it off with the other structure that's there,
right.
yeah.
Um,
Instead of having a gap there, I know what you're saying.
Yeah,
Makes
it's
sense.
just been a headache since I had it, and I
Hmm.
just, that's,
I think down the road you could have the same problem you have now.
oh, yeah.
If you,
Mhm. My kids will have it anyway, if I,
somebody will have it.
somebody's gonna have it.
let's see. So this, Jill, this still does not meet 12.4, correct? Unfortunately.
Unfortunately, it does not. Like I said, it's less than 10,000 square feet. But for the fact that it's in an R20 zone with a wide frontage, it doesn't get the 25%.
That's a unique characteristic. Steve didn't roll his eyes on that one, so. So even if even if it goes to a 10 by 22 deck, it still doesn't meet.
Correct.
I mean, you're taking another 88 square feet off.
Well, he's looking for 10, isn't he looking for 14 by 20 now?
40 by 12,
Yeah.
I'm sorry.
So if you went to 10
Oh,
by
yeah,
20, then you don't have the issue.
It's
Doesn't solve this
80
problem.
square feet, but it still doesn't meet the requirement, the 12.4, but even the fact that it's such an irregular shaped lot. It's still. All right. Does everybody understand what Mr. McGrath wants to do? Any further questions? Okay. I'm just gonna ask if there's anyone who would like to speak in favor of this proposal? Okay, is anyone opposed that would like to speak? Okay. Chair would entertain a motion that we close this public hearing.
Move to close the hearing.
Second.
Motion has been made and properly seconded. Any discussion? Hearing none, all those in favor?
Aye.
Aye.
Opposed? That motion carries 4-0. All right, in regards to McGrath, what is the board's pleasure?
Mr. Chairman, with respect to McGrath, what was the date of the updated project summary? Should-
April 20th, 2023.
dated April 20th, 2023, McGrath, 10 Spring Cove, Tax Assessor's Plat Y-1, Lot 326. I'd like to adopt the following findings of fact. Relief requested is, request is to construct a 14 by 20 rear deck at the above referenced property. The project requires a variance from the dimensional regulations, section 6.4, and a variance special use permit from the Coastal Resources Overlay District, section 4.4. I'd like to adopt facts A through F of the project summary, and incorporate the information submitted as part of the application and the testimony of Thomas McGrath, the property owner, who appeared before us initially at our hearing on
Bless you.
March 23rd, and then again this evening. Mr. McGrath, subsequent to the initial hearing, submitted some revised plans, and has indicated this evening that he's now seeking to build a 14 by 20 foot deck as opposed to a 14 by 22 foot deck. He's looking for a variance of 481 square feet, or 5.8%. We did not hear from anybody else other than Mr. McGrath this evening or at the prior hearing. Nobody testified in favor of the application or opposed to the application. The planning board found the application to be complete and in conformance with the land use component of the comprehensive plan of the town of Narragansett, with a motion that passed 4-0. The planning board recommended the application to the zoning board for denial with a vote of 4-0. That completes my findings of fact.
Add something to that?
You certainly may.
Just procedurally, because I think there was also, in the interim, there was an expert report submitted
Oh, I'm sorry.
by Mr. McGrath that demonstrated that the deck required demolition due to safety reasons, and also gave some information regarding the fact that Mr. McGrath removed the deck, not realizing that it could trigger a need for zoning relief, and that he's merely trying to just put the deck back up in the same way that it was with this little 4-foot addition. So I think we should include that in the
Absolutely.
findings of fact.
Absolutely. I'd like to amend the findings to include Keith's statements with respect to the affidavit that was submitted, as well as Wayne's indication this evening that he accepted the information as accurate. We should submit that. I think it's in the record already.
It's in the file.
It's in the file.
I know we all got it somewhere.
Yep.
Second, I'll second that.
A motion has been made and properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed, that motion carries 4-0.
Mr. Chairman, members of the board, with respect to McGrath, Tax Assessor's Plat Y-1, Lot 326, I'd like to make a motion to approve the relief requested, specifically a 581 square foot relief requested from section 4.4 Coastal Resources Overlay District, a Is that 151 still accurate, Joe?
Yes.
151-foot variance and special use permit. And with respect to section 6.4 dimensional regulations, a 481 square foot or 5.8% lot coverage variance. I believe that the testimony that we heard this evening from, and on March 23rd from Mr. McGrath, indicate the, based on the unique characteristics of this particular piece of property, this relief is appropriate. Mr. McGrath has attempted to work with the board to reduce the initial relief that was requested. He has also provided us with the affidavit from the contractor indicating that he was not aware that he needed this extent of relief in order to rebuild the deck. I believe he's met all of the requirements of the zoning ordinance for this relief. Conditions. And that would be subject to conditions 1 through 5 of the project summary dated April 20th, 2023.
Joe?
Mr. Ullman, could we revise condition number 1 for a revised site plan since the deck has been reduced in size?
Oh, yes. Thank you for that. I'd like to revise condition number 1, that all construction is in conformance with a revised site plan that will be submitted in accordance with the testimony that was given this evening. Is that sufficient, Joe?
Yes, thank you.
Can I get a second?
I'll second.
A motion has been made and properly seconded to grant the relief requested with conditions. Is there any further discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed, that motion carries 4-0. Good luck, Mr.
Thank you, sir.
Good luck.
Thank you, gentlemen and ladies.
Okay, Chair would entertain a motion that we adjourn as the zoning board of review.
Second.
All those in favor?
Aye.
Aye. Opposed?
We're staying with the zoning board, this is
Yeah.
a planning board.
This
This is not planning.
is-
Oh,
Yeah.
we're staying zoning. Oh, I
Staying
didn't
zoning.
know that. I rescind that. Okay.
So, we kind of conferred, and one thought that we had was, first of all, Rinaldi is going to be continued, so we can make that, he's not here, we'll continue that to the regular meeting.
A date certain?
Yeah, to the next, to our regular,
May meeting.
yeah, so, and then for these, we were gonna kind of open all of them. And then I was gonna give my legal spiel, if this is okay to you.
Yep.
Standard, they can give openings, Chris can give openings, and Kelly can give openings, and then we'll go into the specific cases, if that's okay, you know, so that way, we're not giving the law 5 times, we're not giving opening statements 5 times, et cetera, et cetera. All right?
That sounds perfectly reasonable to me.
So, Kelly just told me that they're acting as co-counsel on all of them,
Okay.
Okay.
so,
Oh, so bye-bye.
it's up to you. So, yes.
Yeah.
So
Steve.
I thought she was gonna do one, but you can do that on the record.
Steve,
Do you have a phone?
is it maybe easier to do the general stuff and then continue on? Open it and then
You'll
continue.
open and continue? Okay. Yeah, so we'll open up Rinaldi to give the general spiel for them, so that way, next time, we don't have to give the spiel again for Rinaldi.
All right, so we're gonna open all of them.
Open all of them, we're gonna
And then
hear
we'll
4 of
continue
them.
Rinaldi after
Yep.
the,
Okay,
okay.
got it.
Next item on the agenda. we've got appeals of the building official's decision. We've got 1, 2, 3, 4, 5 appeals. VTRI Secana Boulevard Investments, 9 Exeter LLC, Eastside LLC, Rinaldi, and Mita. Hopefully I pronounced that correctly. Steve?
Yes, thank you, Mr. Chairman. So after conferring with all the attorneys for, I'll call it judicial economy, even though you're not the judiciary, what we thought would be the best thing to do was open all 5 that I'll give you the standard of law that I have given you in the past on appeals of the building official. Mr. Zangari, if he wishes, can give any opening statements. Ms. Roche is going to go over, or Ms. Morris are going to act as co-counsel. They're going to go over their kind of their legal arguments, which I've been told, although are the same for all of these. And then the thought was that we have to play this a little bit by ear because they are separate appeals. Then Mr. Zangari will then do BTRI Secana, we'll do 9 Exeter because they all have different factual circumstances. And the facts may be different, that may ultimately lead to a different conclusion by this board. If legal issues arise which necessitate, or I think, or you think necessitate briefings, then my advice at that point would be to continue all of them, allow the parties to, both the town and the landowners, the ability to brief, and then they can submit that in writing, and then they can make any oral arguments at either the next regular hearing, or we can schedule another special meeting depending on the regular zoning schedule. I don't know. I'm assuming it's getting backed up as it normally is. So with that said, are you in agreement, Mr. Chairman? Well, we're going to play this by ear
I think
because
it's a great plan.
again, it is very, there's overlapping legal issues, but unlike subdivisions or unlike certain, I'll call them joint zoning applications, they are separate entities, separate owners with separate facts. Okay. All right, so again, these are 5 appeals of the building official. Everyone was here for Metatuxet Yacht Club, but I'll go over this again. When reviewing the termination by a zoning enforcement officer, the board may reverse or affirm wholly or partly and may modify the order, requirement, decision, and determination appealed from, and may make any order, requirement, decision, and determination that ought to be made, and to that end has the powers of the officer from which the appeal was taken. So that's kind of right out of our section. The sections that cover this, essentially section 32 to 35 of our zoning ordinance, and state law 45-2468. This is an appeal of the building official, and with our new zoning law, it doesn't really make that much of a difference, but 3 out of the 5, it takes 3 out of the 5 to vote one way or the other. The whole 4-1 is gone away, but this was always either affirmative or negative determination of the board. It only takes 3 of you. As last time, I've always gone under the standard of clear and convincing evidence. That was asked of me last time, so I figured I would certainly say that again. As the board may know, there have been appeals that are currently going on. There was a request for a temporary restraining order in Superior Court. That request was denied. The matter was then removed to federal court, and it currently sits there. Ultimately, it's going, obviously hear all the arguments, but as we stand, it's my opinion that the law on the books is still good until the court of competent jurisdiction tells us otherwise. There may be arguments against that, but that's what this board should go on as we hear the arguments. I haven't received any injunctions or any orders contravening that. So, with that said, Mr. Zangari, I don't know if you have anything initial to say, or if you want.
Very brief. Christopher Zangari, I'm here in the capacity of representing the building official for these hearings. All five are in regard to the ordinance. No more than 4 unrelated people can be in a dwelling unit. These were the substance of the notices of violation. They were issued by the building official, Mr. Pimentel. So those are the things that are all going to be the same for all of these. Also, we're going to introduce, and I'll do it once, the process by which owners register the property and how they do that. I'll do that through Mr. Pimentel. I'll also introduce the actual NOVs, copies that he issued, and the service, the green cards. I'll give you copies of those as well. So I'll be the same for all of them. After that, I'm going to introduce Mr. David Green. He's here this evening. He no longer works for the town, but for all times relevant to these matters, he was the inspector. And I will elicit testimony from him as to who he talked to, what he saw, what he heard, which led to Mr. Pimentel issuing the violations and why they violated the ordinance. That's the layout, what you can expect. It'll be very straightforward.
And just one more, normally we don't allow, or it's always up to the chair, we don't allow cross-examination because none of us are judges. However, they did indicate to me that they would call Mr. Pimentel and ask him questions, so they have the right to obviously call Mr. Pimentel. So in that case, we're going to try to figure out how those questionings are going to go, but Mr. Zangari would obviously go first. And for this, or Alicia, for you guys, do you want the questioning and the attorneys to go up to the podium, or?
It doesn't matter, whatever's easiest.
Okay, all right, sorry. Okay.
Steve,
one question.
Oh, yeah,
I
I'm sorry.
may add, just so the general public knows, we're only receiving testimony or.
Correct, yeah, and as is the past, and every appeal I've ever done is it's not open for public comment.
Right.
It's an open meeting, but it's not, we don't take public comment on an appeal.
Mr. Chair?
Yes,
I have to recuse myself from evidently all of these matters due to my unique relationship with one of the co-counsel on all of the matters. So
Okay.
just want to put that on the record.
Thank you.
And then Heidi, you'll get a form.
I'll get her.
Okay, all right.
Tony, you had a
Yes,
question?
Steve, you
Yes.
indicated the law is still on the books and effective. Which law?
So Mr. Zangari will go over the violation. It's essentially what is colloquially known as the 4 unrelated, that statute, which is noticed in, as the it's in the violation, it's in the notice of violation.
Thank you.
So you should have 5 separate ones. I believe the dates are different, but the law, the written law is the same.
Steve, one other matter, I know we raised this last time, but I just maybe make sure it's on the record just in case. I think is the town represented in federal court by DeSisto and DeSisto?
The town is represented in federal court by DeSisto law. Should, practically speaking, Mr. Zangari is representing the town today, but practically speaking, should legal briefs be needed to you guys from everybody, most likely DeSisto law will, Kathleen Daniels, I call it Kathleen Pye, I went to law school with her,
Yeah.
will probably write those and then get those to you, but that's something that they would work out separately.
All right, so I just want to disclose that Kathleen and I are co-counsel on a case pending in, a couple of cases pending in federal court and superior court. I don't view that as a conflict, but.
Yeah, and I don't either, but.
We're just on completely unrelated matters, but, it's like, I think I know all the lawyers who are sitting in this room too, so after 35 years, I think you pretty much run into everybody, right, Chris?
You do. We all do.
So, I just want that to be on the record.
All right, thank you.
Excuse me, sir. I received a letter about this hearing, and I'm having difficulty hearing. Did you say that it's not open to comments, or?
Correct.
Why?
So why did I receive the letter about this hearing?
About hearing.
See that property on the very bottom? The very bottom of it, where you can basically see the driveway? That's my property. And I received a letter about the property that this hearing is about. Now, if I'm not allowed to comment, why did I receive a letter notifying me to attend?
Well, I'm not your legal counsel. I can tell you that under our statute, any appellant is required to notify.
I'm not an appellant, I'm not named in this. I apparently have standing because of my proximity to the property that was in
Correct,
violation.
and because you have standing, you certainly can hire legal counsel. You would have the right to join in any appeal, but again, I'm not here to, not trying to be rude, I'm not here to advise you of any legal matter. However, tonight is an appeal of the decision of a building official. There's different rules that apply as opposed to a planning board or a zoning board.
Okay, so basically I should have been notified of the original hearing, and I would have been able to comment at that original hearing?
This is the original hearing. This is the first hearing.
I thought you said this was the appeal.
This is an appeal.
Of a determination of a building official. There has been no hearing yet. This is the first.
Okay. All right. Why would I need counsel? Why did I receive a letter notifying me of this hearing, and why would I need to obtain legal counsel?
Can't advise you of that, ma'am.
No, but I'm asking the question. Why was I notified
Ma'am,
to attend here tonight, and you're telling me that I can't say anything or participate in any manner?
No. And that's the way we handle these appeals. It's not a regular public hearing, like the one we just had with Mr. McGrath, where someone is invited to speak. This involves the board. We make a decision. It's just the parties that are involved in the appeal. You were probably notified because of the proximity to one of the dwellings.
Okay, well, I'd just like to state whether it's full of
ma'am,
record or not.
ma'am,
No.
you gotta, we're gonna, the attorneys haven't even spoken yet.
I know,
Ma'am,
I
ma'am,
understand, but please,
Ma'am,
I have had my property driven on, I've had my house
Ma'am,
attempted
That's
to be
not what
broken
we're
in.
here for
Ma'am.
this evening. We
Well, the town
understand.
doesn't seem to care about the people that have lived here their
Ma'am.
entire lives,
Ma'am.
and these students are overtaking the properties.
Just
All right.
And
Ma'am,
for the
ma'am,
property
ma'am,
here.
please.
for the record.
This
Okay,
is,
Joey, you can do it.
this is not the time and place for that.
Will
Thank
there
you.
ever be a hearing?
Yeah, well, yeah,
Public hearing?
when will there be?
Would you please allow us to conduct our business?
Taxpayers get screwed
Yeah,
again.
yeah, we don't matter. The people that have come in here and bought houses to make money and
All right,
have
ma'am.
destroyed our
Please.
quality of life, we don't matter.
I understand, all right?
This ordinance has been tried
Excuse me.
before.
Proceed or we're gonna have to.
They hire these fat
Well,
cat lawyers.
do you want to arrest me?
Enough is enough, all right?
Well, I'm just saying, would you like to
I-
arrest me? Maybe I'm the criminal here. Maybe I don't
think
have
you're
a right to a
criminal.
quality life.
We're trying to conduct
Okay.
a hearing, thank you.
Joe, would you like to make a motion to strike that?
Yeah, move to strike that entire, all the statements that were made by the public.
Okay, thank you.
I just need your name.
Oh, sorry, Joelle Rocha.
Who? Speak
So
up.
I'm one of the council tonight on these matters, and I just want to say, just for the record at the outset, we're just trying to see how many lawyers we can get on this matter from both sides, but I'm here tonight with my esteemed colleagues, Kelly Morris Salvatore and Andrew Blaze, and the three of us will be participating like your solicitor said, we've tried to create a mechanism tonight to streamline these, to try to not be repetitive, and in consideration of the board's time on all these appeals. So your solicitor indicated a few things that I was going to highlight. One is that we are in federal court with respect to many of the claims that are relevant for today, and really challenging the forced student ordinance itself, the enforcement of that ordinance, and some principles of law, some non-conforming uses you're going to hear about tonight. To summarize those arguments, to give you some background on this, we're here on a 2016 for unrelated, and I'm going to get that wrong because 3 student, 4 student, for unrelated, but for unrelated ordinance that was passed in 2016. You may or may not be aware, but in 2017, your municipal court declared the for unrelated ordinance unconstitutional, based on a variety of constitutional principles, including equal protection that you'll hear about tonight. From that time until 2022, there's no word about the for unrelated ordinance until these violations happened. And they suddenly, after the three student ordinances both were declared invalid, you now have these violations before you as to a 6-year-old ordinance. As to equal protection, the courts along the way, in both municipal court and superior court, have indicated that this ordinance and ordinances like it in the town of Narragansett are violative of equal protection on a rational basis. That means that the court found that there's no rational relationship to regulating for unrelated versus for related. And that decision was based on, and we'll enter that later into the record, but it was really based on, and this is contained in the DiStefano decision in Superior Court. And you'll get a brief all about this, but it was based on statements made by actual town officials saying, we don't see the basis for this because you have the same issues, parking, traffic, whether the people are related or they're unrelated. And on that basis, it was a statement from the police chief, it was a statement from the town manager at the time. The court said, we don't see a relationship to single out related versus unrelated. Obviously, there's a contentious issue about students in this town. And that students have been regulated over the years. This is not a student ordinance, it's a for unrelated ordinance. It just happens tonight that you have violations with respect to students inhabiting these houses. On that end, this ordinance was not enforced for 5 years. And it's not enforced to non-student rentals, it's not enforced for the majority of rentals and summer rentals. So on that basis, you'll hear tonight also about the fact that these property owners have been renting their houses since before the ordinance was put into place, otherwise known as a non-conforming use. They've continued to do so without issue until November 17, 2022. So there's a legal basis based on that, which I'll summarize at the end, and I'm sure we'll submit briefs to you. With that being said, that's my intro. I'm here for any questions. I'm trying not to be long-winded, and I'll turn it over to the town.
Yeah, Chris, it might be better if you and Wayne go up there, just because we're on camera too.
This is 36. The first one we're going to address is 36 Saconnet Boulevard. That's the BTRI Saconnet Boulevard Investments matter.
Steve, do we want to make a motion on Rinaldi now, or?
Are you
done with the global arguments, or, again, just for Rinaldi?
If I may, Kelly Morris Salvatore. So some of the questions that I will have for Mr. Pimentel relate to all of the matters. And again, we're trying to do it as a matter of efficiency and not to cloud the record. So I just want to be clear that although Joelle made her opening, I'm also going to be questioning Mr. Pimentel on global issues relating to all of the matters. I think that we have a court reporter here. We can be very clear about whether something is globally related to all of the matters or whether they're specific to individual properties. And if we're providing briefs to you, those briefs will also be very clear.
Joanne, why don't we keep it open?
Okay, that's fine.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
My name is Wayne Pimentel. My last name is Pimental.
Thank you.
Mr. Pimentel, who's your employer?
The town of Narragansett.
What do you do for the town?
I am the building and zoning official.
And is one of your duties as the building and zoning official to issue violations of the town ordinance, should it be necessary?
Yes.
And in the instant case, the BTRI Secundit Boulevard Investments, did you have occasion to issue a notice of violation?
I did.
I give the board copies of the violation, among other items. And you're also going to get one of these. Everybody gets one. You're welcome. I think I do. Mr. Marcello, do you usually admit them more formally, like exhibits? We can do that.
Yeah, we do.
Yeah.
Yeah, we do.
Let's make it Town's Exhibit 1. And what you have before you is a copy of the notice of violation dated November 17th.
So, oh, I'm sorry. I believe our secretary is not here, Mr. Callahan. Are you,
No, I'm the secretary.
No,
Oh, you're the
Joe is
secretary.
secretary.
Okay. Joe? I apologize. All right, go ahead.
Okay, the first page, Mr. Pimentel, what is the first page of Town's Exhibit 1?
Is the zoning ordinance violation dated November 17th, 2022.
And the second page underneath it is what?
There's the certified mailing receipt.
I'm going to ask you 3 pages later, there's a form and it's blank. What is that form?
That's the rental registration online form.
That's a copy of what you would see on your computer screen in the portal.
That's correct.
And the next page, can you describe what the next page is?
That is the rental registration certificate that's issued after someone applies for a rental registration and pays for it. We then issue that rental registration form.
And the rental registration for this property, is it for what year?
2023.
And who is the owner who filled this out, or the person, strike that, who's the person who filled this out?
The agency, Anna Ryan Realty.
And who is this person, Brian Tomasello?
I believe they are the representative of BTRI Secundit Boulevard Investments.
Okay. And when was this issued?
November 9th of 2022.
And in the top box in the middle, under where it says certificate, it's got the property address, correct?
That's correct.
It has a plat and lot reference, correct?
Correct.
Does it list the number of bedrooms?
It does.
How many?
6.
It lists the number of tenants?
Yes.
How many?
6.
And this would have been completed by who?
By the applicant.
And the last, go ahead.
This one.
Is there a certification by the owner or the applicant at the bottom?
There is.
And who signed that certification?
Brian Tomasello.
And in that certification, what does it state?
It states that they hereby certify that the above information is true and correct, and they understand that any false statements made herein are subject to penalties under law.
And then the last page on the back is a copy of
The ordinance that was cited
in
in the violation letter.
the ordinance from,
May 16th of 2016.
otherwise known as the 408.
That's correct.
Okay. Now, I also gave to the board a legal size piece of paper. What is this, please?
That is the previous rental registration form.
And who signed, it was, strike that, it was notarized. Who signed it?
Brian Tomasello,
And it was notarized by who?
Donna Drogo,
Okay,
Donna Drogo Richards.
all right. Now, why did you issue the violation on this particular property?
We had gotten a complaint that there were more than 4 unrelated persons possibly living at that address.
Who made that complaint?
Let's see. That was an S. Ferrandy.
And when was that complaint made?
That was done on September 13th of 2022.
And because of that complaint, what actions, if any, did you take?
We sent our rental inspector out to visit the property,
And who was the rental inspector?
David Green.
Is he here this evening?
He is.
Very good. And what did Mr. Green tell you, if anything, about what he did, what he learned?
He has a email correspondence to myself and other people in the office that after receiving the complaint, he went out there to 36 O'Connor Boulevard, spoke with one of the renters who showed him a copy of the Ann O'Brien lease, which had 6 names on it.
Did the 6 appear to be related, or do you know?
We don't know for certain, we're assuming as
No, I'm
counsel.
only asking you. Do you know?
No.
All right, I'll ask Mr. Green. All right. So I think what I'd like to do is, I'd like to continue with Mr. Pimentel on all the properties. Everybody sound good?
Yep.
Everybody can go grab the rest of my files.
Yep. Board, are you with me?
Yep.
I'm with you.
Okay. Okay, next is the 9 Exeter Boulevard property, 9 Exeter LLC. You have that one, Mike?
Yes.
And this is for the next property, one for everybody.
Like, you know,
Council, you have one for all 5 pages, you're okay with that, right?
Yes, yes, I think that's fine. Did you issue a notice of violation for this property, Mr. Fernando?
I did.
And what date was it?
November 17th, 2022.
Is this also regarding the 4 unrelated
It is.
ordinance? Did you send the certified mailing?
We did.
Okay. Was there a rental registration for this property?
There was.
And is for what year?
2023.
And it was certified by who?
Karen Rio,
And do you know who she is?
I do not know.
Do you know if she's the owner or not?
I would assume she is because 9 Exeter LLC is the only name mentioned on here. If there's a property manager, that would be, information would be posted here. So I assume she's a representative of 9 Exeter LLC.
And this registration was issued on what date?
October 31st of 2022.
And
Oh, we know that.
in the... Just want to keep it clear for the record, please. Now, the address under the certification is for what property?
9 Exeter Boulevard.
And the plat and lot that's listed,
Is S1, lot 129,
number of units,
1,
number of bedrooms,
4,
and the number of tenants listed by Karen Briel, who certified it.
10.
Next page, is this a receipt for the registration?
That was a prior year receipt, yes.
Was this house a subject of a nuisance?
Yes, it was.
And when a house is a subject of a nuisance violation, what does that mean?
Means there was a police report, complaint, the police responded and found it necessary to post the house as a nuisance house.
Did you receive any correspondence from Mr. David Green upon his inspection of the property?
I did.
And what date did you receive that correspondence?
November 2nd of 2022.
It's one sentence, if you could read it into the record, please.
Sure, on 11/2/2022 at 8:17 a.m., I responded to 9 Exeter Boulevard to view the lease that was not available on 10/24/22, which was the day the house was posted as a nuisance house. Upon his arrival, he did view the Ann O'Brien lease, which was posted in the house, which had 5 names on it, which was verified by one of the renters.
Did you have any further discussions with Mr. Green as to whether or not those 5 individuals on the lease were in fact related or unrelated?
I did not.
We'll ask Mr. Green. All right, let's go to the next one. Okay, the next property is 11 Walcott Avenue. This is East Side LLC. All right, so this can be Towns Exhibit 3. Is it 4 or 3?
We're on 4.
You're on 4?
We have 1, 2, 3, 4.
This will be 5?
Yeah, Chris, for the record, they split out that long, right? You split out.
Oh, okay. That's fine, as long as you have it labeled.
This is 1, so this is 5.
Did you issue a violation for this particular property?
I did.
What was the date of that violation?
November 17th, 2022,
And it was for violation of the,
foreign related ordinance.
did you also, is that a copy of the certificate, excuse me, the green card?
Yes, it is.
The rental registration for 11 Walcott Avenue. Is this a copy of it?
That is
For what year?
2023.
And who was the certifier?
Jonathan Preston,
And this was plat and lot number what?
S, lot 140,
Number of units?
1,
And Mr. Preston indicated the number of bedrooms as to how many?
8,
And the number of tenants, what did he list?
8.
Did you receive a complaint about this particular property?
I did.
And there's a copy in your package. Was the complaint anonymous?
No, it was not.
Oh, you have a different one than I do. What do you have?
I have that one. Let's see.
Well, who's this complaint from?
This is a complaint from Maria Angela Ionati,
And what was the date on that?
August 23rd, 2022.
And what is her complaint? What does it state?
This property is being rented as a 2-family dwelling. This property this property has their grill and picnic bench and chairs, I believe, on her property.
Do you have this copy as well, the anonymous?
Yes,
I've given it to the board, so I'll ask you to look at this one. What was the nature of this complaint from the anonymous source?
It was a single-family house being rented as a two-family. New owner has stated that the tenants, he intends to rent it in this way. Current occupants confirm this.
Now, based on those complaints, what did you do? Did you have Mr. Green go out and inspect?
Yes, I did.
What did he tell you about his findings?
On October 18, 2022, he reported his findings to me via email, and I can read the excerpt.
Please.
This follow-up report is to explain the status of 11 Wolcott Avenue. After reviewing a complaint that the house was being rented as a two-family home, I had an opportunity to speak with the owner of the house, Jonathan Preston. Jonathan told me he was not renting the house as a two-family. However, he did tell me that he was renting the house to 8 URI students. I responded to 11 Wolcott Avenue several times, but were unable to see the lease. On my third try on 10/12/2022 at 9:20 a.m., I was able to speak to the renters, who stated they did not have a lease, but that they were all URI students and that they all lived there. I was able to obtain their first names, which are Angelia, Alexis.
Please do not put their names out.
These are first names.
These are first names only.
Okay, I heard a name and I'm, sorry, they're girls.
Continue on.
Danielle, Emily, Madison, another Madison, and Katrina. The house owner to be notified of the ordinance violation.
Let's move on to the next one. Okay, last one, 49 Joy Lane. This is Michael and Lee Mita.
Chris, I'm sorry.
Yeah.
Can I have a copy of what you just used to question him when you had a chance?
Yeah, absolutely.
Thanks.
Is your name?
Yeah.
So just for the record, we're skipping Rinaldi, which is 45 Sylvan Road.
Right.
No, I think we can put that part in the record, it's just Rinaldi's testimony.
What, we're skipping
Okay.
Rinaldi, we can do that all at once. We can have Mr. Fermento, he'll be here.
Yes.
We'll do it all at once, because you guys will be back.
Okay, Mr. Pimentel, I'm going to show you what's been marked as towns number
6.
Thank you, 6. You recognize the top document?
Yes, I do.
And that's a notice of violation?
It is.
And it's for what ordinance?
The four unrelated ordinance,
Underneath that is what?
the certificate of mailing.
And next we've got the, can you identify that document?
That is a 2022 rental registration form.
This looks a little different. This isn't the portal, is it?
That's correct, it is not.
This is a handwritten,
Yes.
and it's notarized, and the notary indicated that the signer of this document is who?
Michael Mita.
And on this particular document, it's regarding which property?
49 Joy Lane.
Number of units?
1.
Number of bedrooms?
6.
Number of tenants as indicated by Mr. Mita.
12.
Did you receive a complaint regarding this property?
Yes, I did.
And who's it from?
Rick Tettelbaum.
What's his nature of his complaint?
Violation of the 3 college students to house ordinance. 7 students are occupying the house. Pictures and license plates were attached to the complaint form.
And that complaint is dated what?
9/8/2022.
And there's also a list, who created this list of cars that were in the driveways? 1, 2, 3, 4, 5, 6, 7 cars.
I would have to refer to
If you don't
Mr.
know, it's
Green.
okay.
Yeah, to see
Okay,
if
if you don't
that's something that he wrote or if that was part of the complaint.
All right. And there are some pictures attached to that. Did you take those pictures, or was that Mr. Green?
That was submitted with the complaint.
All right, so that was Mr. Teitelbaum?
Yes.
And you issued the violation based on the information you received from Mr. Green, correct?
That's correct.
As with all these four matters that we've just gone through, as to all the four matters that you just testified to, what was the reason you issued the violation regarding the four unrelated?
Through complaints.
You didn't go looking for these people?
We did not.
These were all complaints by who? Ordinary citizens or?
Ordinary citizens, or if it was a complaint to the police department as a nuisance house.
You also showed me an email that you received from Mr. Green regarding this particular property, 49 Joy Lane. And what was the date of that email to you from Mr. Green?
November 2nd, 2022.
What does it say?
On 11/1/2022, I responded to 49 Joy Lane to post the house as a nuisance house with the Narragansett Police Department. All 6 renters stated they live there but have no lease. And that was the end of that report.
I'll give that back to you. All right. Now what I think I'd like to do next is, I think I'd like to bring up Mr. Green, and then you can recall Mr. Pimentel. Sound good? All right.
Chris,
Yes.
just a housekeeping issue, if we could have, to one of the appellant's points, any personal information that is in those registration forms, since the appeal record becomes public, if we could just redact those at some point.
Isn't the violation?
No, not the violation. I meant the renter information.
The
There is
PPI,
none. There is no rental information.
On the
Renters-
registration forms?
No.
No, we
It
got
only lists
rid
the
of
number.
that.
Okay,
I
the
mean,
new, okay. There's, the lease is not attached.
no.
Okay,
It
understood.
just, the registration has the number of units, these are all single family,
Right,
and the number of tenants, as put in by the applicant.
okay.
All right, next we're gonna have Mr. David Green, please.
Please raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please state your name and spell your last.
David H. Green, G-R-E-E-N-E.
Thank you.
Mr. Green, do you still work for the town of Narragansett?
No,
How long did you work for the town?
7 years.
Before you worked for the town of Narragansett, what was your occupation?
Police officer in Cranston,
How long were you a police officer in Cranston?
28 years.
Did you retire from that job?
Yes, I did.
Very good. How, you said you worked for a number of years for Narragansett.
7 years
In what capacity?
as the housing inspector.
Did you have any other duties besides housing inspector?
Yes.
What were they?
I rode with a police officer, and we would respond to the homes that there was a complaint filed, and it was a noise complaint or a trash complaint or unsafe issue, parking, something related along those lines. And spend time with the students discussing the noise complaint.
Oh, sir, if you could just, Alicia, can you hear him or?
A little bit.
All right, yeah, if you could just speak up just a little bit so Alicia
Okay.
can hear you. It just-
Let
thank you.
me ask another question.
Sure.
Let's get into the first board members. Which property did we start with?
BTRI.
GTRI? Which, Steve, what was the address on that?
That is,
36 Secana.
Thank you. Do you remember 36 Secana Boulevard?
Yes.
And do you remember about what time you were out there? I mean month.
Several times.
Okay. And why did you go out to 36 Secana?
We received a complaint that there was more than 4 unrelated living here. And I responded up to that address to do a follow-up.
And was that property being managed by Ann O'Brien Realty?
Yes, it was.
Who was the contact there, if you even had a contact, at Ann O'Brien Realty?
The person that I know through Ann O'Brien, Joe Robenheimer, president, I guess,
All right. So, did you have a chance to meet Joe Robenheimer at this address?
yes, I did.
And did you have discussions with him?
Oh, several.
And what did he tell you?
Just that it was rented to more than 6 people, more than 4 people, and that he felt it was appropriate and it would be okay to do that.
Did he tell you if they were related or unrelated?
In the process of my discussion, I would, as frequently as I could, always use the terminology in the charge of former related students. So,
Did he identify the occupants of that 36 Secani as related or unrelated?
he never distinguished.
Did he ever show you a copy of the lease with, if there was a lease, of the tenants?
Yes,
And when you viewed that lease, what did you observe?
that it was a lease that it had the 6 names on it.
And did the 6 names have the same last name?
I don't recall.
Do you recall if they had the same last name?
I don't recall.
All right. Did you take a copy of the lease with you?
I did not.
Based on the information you received from your well, strike that. How many other times did you go back out to the property?
There were multiple times prior to that time that I had responded to the property.
And when were those times?
They were prior to this.
I understand that. How close in proximity? Weeks, days, years?
Within this entire time frame, within weeks.
And did you have opportunity to speak to any of the tenants directly?
Not that I recall.
Did you have another opportunity to talk to Mr. Robenheimer?
Multiple times.
Did he ever tell you that the students were related or unrelated?
He never indicated.
Did you ask?
I would always say for unrelated students.
Did you ask?
Just as I said it to you, that's how I said it to him.
Did you ask him, are these people related or unrelated?
I said to him, I'm calling you, and the reason we're gonna go out here is because it's in violation of the four and related. I didn't say it's in violation of the four, are any of them related or not?
Okay.
And the word related never came up in any conversation.
Now, when you went out there and you said, I'm here because of the 4 unrelated statute, did he ever deny it and say, no, they're related?
No.
Based on the information you received from Mr. Robenheimer and what you observed, what did you do?
There's a report to Mr. Pimentel indicating that there was more than 4 living here.
The next one, 11 Walcott Avenue, this is East Side LLC, that'll be next. Do you remember this property, Mr. Green?
Yes.
11 Walcott Avenue.
Yes.
Did you have opportunity to visit the site?
Many times.
All right, can you tell us the time frame when you visited the site?
Started around August of '22, and that was not involving the students, but split, renting out the home as 2 separate homes.
Mr. Green,
for that.
excuse me, could you turn towards the
Yeah, I'm
board
sorry.
when you're speaking? It's just,
I responded there initially because that address came up as a complaint that it was being rented as 2 separate homes, but it's one big home. Maybe it was 2 homes maybe a long time ago. Anyhow, it's one large home with opposing frontages on each side, and we got a complaint that it was being rented as 2 separate homes. So that was my initial going there, but it wasn't URI students at that time that I can recall. It was summertime rentals.
When you went out to the property, did you ever have occasion, strike that, try again. When you went out to the property, did you encounter Jonathan Preston?
Not at the property that I recall.
Where did you meet Mr. Preston, if you met him at all?
In passing and on the phone, we spoke several times.
Okay. When you spoke on the phone, did he identify himself?
Yes, he did.
Okay. And your discussions on the phone, after he identified himself, what did he tell you?
Initially, he had a concern that he was being singled out, and had a concern that why was I checking on his house, which I explained that one large house will be a plain that was being rented as two. At any rate, that progressed into the September of him renting it to a lot of students, and he very frankly and openly said that he did rent and that he felt he had the constitutional right to do that, and that he was renting to.
Did he admit to you that he was renting to more than 4 unrelated individuals?
Yes.
He specifically said that to you?
Yes.
All right. And you just testified that he did that because he felt he had a constitutional right, is that what he told you?
Yes.
All right. Based on what you learned from Mr. Preston and the documents that were submitted already that were in the portal, what did you do, what did you tell Mr. Pimentel?
The supplement that I believe was read off earlier in testimonies indicating that, first of all, he had indicated that the owner did rent to more, and that one of the times I did stop there, I did have a chance to get the first name of the people that were renting there. I believe there were 8 of them.
My question was, based on the information that you had, that you gathered, plus the admission that you just testified to from Mr. Preston, what did you tell Mr. Pimentel?
That there were more than 4 unrelated living at that address.
All right. Next property, 9 Exeter Boulevard. This is 9 Exeter LLC. Mr. Green, do you remember 9 Exeter Boulevard?
Yes.
You remember going out to the site?
Yes.
All right. When you went out there, did you speak to anybody?
I don't recall offhand about 9 Exeter without looking at my records, or that. I believe that was a supplement that was called in. Could I refer to that?
Yes,
Yeah,
sure,
yeah.
yeah. Go ahead. You can go ahead. Okay, Mr. Green, you've handed me what is an email from you to Wayne Pimentel. It's dated November 2nd, 2022. Is that the email you sent to Mr. Pimentel?
Yes, just so I don't get it confused, right, this is reference to 9 Exeter. I'm on 11/2/22, this is already ready.
Hold on, I want you to slow down. And it's a 1-sentence email.
Thank you.
Could you read that email into the record, please?
On 11/2/22, at 8:17 a.m., I responded to 9 Exeter Boulevard to view their lease that was not available on 10/24/22, which was the day the house was posted as a nuisance house.
Go ahead.
Upon my arrival, I viewed the Ann O'Brien lease with the 5 names on it, which was verified by one of the renters.
All right. The 5 names on the lease, do you recall if they all had the same last name?
I do not recall.
All right. Did you speak to anybody at the property? Did you speak to any of the tenants directly?
It's not indicated, however, for me to see the lease, I must have been allowed to, yes.
Okay. When you had discussions with any of the renters, did they tell you if they were related or unrelated?
No one ever said they were related in any way.
Okay. Take those. That's good. All right. 49 Joy Lane, this one is Michael and Lee Mita. Do you remember going to 49 Joy Lane?
Is that a supplement also? Could I?
Yeah, please.
Jill? I don't think we need
Okay.
the background. I think it's
Excellent.
just probably bothering the witnesses more than,
I did respond to that address
And why did you respond to that address, Mr. Green?
because we received a complaint that there were more than 4 students living there unrelated.
All right. And how many times did you go to that property?
Many times over the course of the weeks.
And give us a time frame. Would that have been when?
September to November
Of which year?
of 22.
All right. And when you went there, did you speak to anybody?
I did, it's not indicated here, I don't recall who I spoke with, but in this report that was read out, it's indicated I responded to 4909, I post a house as a nuisance house within my PD. So the six students that were there, I spoke with them because I said there were 6 renters there. But because this was a nuisance house, this is a house that the police department participates in finding out all the information. So, yes, a list of the 6 people that lived there are on the police report.
Do you have the police report?
Yes, but it might be redacted.
No?
No.
Now, you took pictures of the driveway with certain cars in there?
No, I did not.
Oh, that was a neighbor?
Yes.
I see. All right. Now, based on what you observed and what you learned at 49 Joy Lane, did you report back to Mr. Pimentel?
Yes.
All right. What did you tell him?
That we responded to that house. It was a nuisance complaint house, which allowed us to get even additional information that who was living there and that there were more than 4 unrelated living.
And based on that, the notice of violation was issued?
That's correct.
All right. Thank you, Mr. Green, but stick around for, in case you get called by the appellants. That's all the properties for tonight. That's Mr. Pimentel, that's Mr. Green. Mr. Marcella, do you want to? Oh, the town rest.
Oh, yeah.
Just one minute.
Mr. Chairman,
Good evening.
good evening. For the record, my name is Kelly Morris Salvatore, and I am co-counsel with Joelle Rocha and Andrew Blaze regarding these 5 matters. If I may, just to make it easy, I thought I'd recall Mr. Green for literally 1 question, and then we'll proceed with Mr. Pimentel. Maybe Mr. Green can go home after that.
That's fine. Thank you.
Mr. Green. So with regard to, and this is specifically relating to 11 Walcott Street. With regard to 11 Walcott Street, you visited that property on or about October 18th, is that correct?
I don't recall.
On or about?
On or about, yes.
Thank you. And when you got back to your office, you wrote Mr. Pimentel an email, correct? That I think Mr. Zangari showed you.
Yes.
Okay. Could you read that email to the board?
Yes. This follow-up report is to explain the status of 11 Walcott Avenue. After reviewing a complaint that the house was being rented as a 2-family home, I had an opportunity to speak with the owner of the house, Jonathan Preston. Jonathan told me he was not renting the house as a 2-family. However, he did tell me that he was renting the house to 8 URI students. I responded to 11 Walcott Avenue several times, but were unable to see the lease. On my third try, on 10/20, correct, on 10/12/22, at 9:20 a.m., I was able to speak to the renters who stated they did not have a lease, but that they were all URI students and that they all lived there. I was able to obtain their first names.
Thank you. So when you testified earlier, you mentioned that Mr. Preston said that they were unrelated, or that he said that they were unrelated, but yet in your email that you prepared immediately after visiting the home, you did not mention anything about the students telling you that they were unrelated or Mr. Preston telling you that they were unrelated. So I just want to give you the opportunity to clarify, because on all of the other properties, you said that nobody ever talked about unrelated to you. You went out there on an unrelated issue, but that nobody ever mentioned that. So I'd like to give you the opportunity to clarify. Would this have been, does this refresh your recollection as to what Mr. Preston did and didn't tell you?
Not what Mr. Preston told me. However, when I responded to the house, I would always approach them, identify myself, explain why I was there and the purpose of my visit, and then say that I'm here because we received a complaint that there's more than 4 unrelated occupants living here, students. Is that true? Or I would ask them, you're all, and they were like, yes, we all live here. Now, no one's ever said to me they ever were related. And if they ever said to me, like, oh, I'm related to someone, it would stop everything, because I wouldn't know how to begin to find out how they were actually related to the other person.
Okay, thank you. But they also didn't say that they were unrelated, correct?
I don't recall if they said they were unrelated.
Thank you. That's all I have. Okay, and at this point, if we could recall Mr. Wayne Pimentel.
Hello.
Hi, how are you?
Good, thank you.
Okay, so I have some questions. I don't want to be repetitive, but some of my questions were not asked by Mr. Zangari. So how long have you been employed by the town of Narragansett as the building official?
2.5 years.
Okay. And in your capacity as the building official, you're also the zoning official, correct?
That's correct.
Okay. And as the zoning official, you are responsible for enforcing the Narragansett zoning ordinance, is that correct?
That's correct.
Okay. And obviously you are familiar with the violation notices that you just went through with Mr. Zangari. Have you ever issued a violation based on this unrelated ordinance prior to November 2022?
No.
And I'm going to skip that question. Mr. Chairman, I'd like to have this marked as Exhibit A. That's for you. I'm going with A in letters.
Fine.
Now, I don't have lots of copies, but I have a few.
That's our secretary, please.
So, Mr. Pimentel, what I've handed to you that's been marked as Exhibit A is the ordinance itself relating to the definition of household. And this definition is included in every one of those violations that you issued, correct?
I believe so, yes.
Okay. So I'd like to review this provision with you so that we all understand it. Can you confirm that the highlighted portion is contained within the definition of household?
Yes.
Okay. Now, the definition says...
Oh, hold on, what is the highlighted?
Sorry, I thought you had a copy, Steve.
No.
So this is...
Steve,
In,
exhibit A.
I'm sorry.
yeah.
Okay.
just for the record, the highlighted wording is for determining the number of such units allowed within any structure.
Okay, and now I'm just gonna read the whole sentence in context. So the term household unit shall be synonymous with the term dwelling unit for determining the number of such units allowed within any structure on any lot in a zoning district. Right? Is that, I just read that correctly?
Yes.
Okay. Does this definition state that the term household unit is synonymous with dwelling unit for any other purpose other than determining the number of such units allowed within a structure? Take your time.
Can you say that once again?
Does the definition, and read the whole definition, does the definition state that the term household unit is synonymous with dwelling unit, like it is for determining the number of such units allowed in a structure, for any other purpose?
Well, it's household, not a household unit, just defining what a household is comprised of.
So it says the term household unit shall be synonymous with the term dwelling unit for determining the number of such units allowed within any structure. Is it synonymous with dwelling unit for any other purpose?
Not that I'm aware of.
Okay, thank you. And is the term household unit, to your knowledge, contained anywhere else in the zoning ordinance other than in this section?
I'm not sure.
Right, sorry. I'm now giving you a copy of what I'd like to be marked as Exhibit B. I think I know who to get these to. So, what you have there has been marked as Exhibit B. And what is that, Mr. Pimentel?
That is the table of use regulations in the zoning ordinance.
And is that the entire table of uses?
Without going into detail, I would assume that you printed the whole table.
I can tell you that I did.
All right.
All right. So what I'd like to know is the term household unit contained anywhere in the use table?
No.
Okay. Is the term dwelling contained in the use table?
Yes.
So if I were to ask you if my household unit is an allowed use, what would you say?
Yes.
How would you say that? It's not in the use table.
Because the terms are synonymous in the definition.
For determining the number of such units allowed within a structure, correct?
Yes.
So a household unit is not synonymous with dwelling unit as a use in the use table, correct?
That's correct.
Thank you. Now, I just want to go over this registration process, again, relating to all of the violations. I thought I heard Mr. Zangari go through one set of, one registration from 1 year on the first item, BTRI, and then ask you to look at the previous year's registration, right? Do you remember that?
Yes.
Did you look at prior years before that?
There was no need to.
Okay. As the zoning official, don't you have to consider whether a use is grandfathered before you issue a violation notice?
We don't look at whether or not a use is grandfathered relative to rental units.
Okay, I mean, you're taking the position that they're violating the zoning ordinance as a use, and you're not looking at nonconformance.
Again, we look at each rental registration as it comes in every year independently of the use, as far as any previous use that they had on the property. Because the uses change from year to year, from property to property, as far as how they rent it, whether it can be an academic, it could be a summer rental. They may not rent as many, they may not use as many of the bedrooms, and their tenant count can vary. So there's no way to determine what would even be a legally non-conforming use.
Well, okay, so if you looked at every registration for the last 10 years, and they all listed 10 tenants, that would be a way to figure out non-conformance, correct?
We would certainly look into that, yes.
Okay, but you didn't on any of these, correct?
As far as what was done previously?
Right.
No, we look at them year to year and we address them on a yearly basis.
Okay, thank you. And are you generally aware of student housing complaints generally?
Yes.
And how many, can you give me a range of how many you receive, or have received since September to present?
Between regular complaints from residents and nuisance complaints to the police department, I would say probably 30 to 40.
Okay. And you would have Mr. Green go out and check out each one of those, correct?
Depending upon the circumstances, especially with police reports, depending upon what type of a complaint it was, would determine whether or not he would go out for those individual police reports. For complaints received through our office, we would investigate all of those.
Okay. And so has he investigated reports that, and reported back to you that there are more than 4 unrelated persons other than these 5 violations?
Yes.
Okay. So the question is, why have these 5 people been singled out then?
It was after these were sent out, there were still additional properties that we received complaints on, verified the complaint, and were advised through the previous legal counsel to hold off on those until these were, the appeal for these went through the system, rather than continue to get more appeals on and back up the zoning board and the court system with additional appeals.
So these 5 properties are just test runs?
I wouldn't say they're test runs. The other ones are basically waiting for the full violation to be issued.
Okay, and you issued these in November. So when would you expect to be issuing those?
Once we get a determination on the validity of this violation, these violation notices.
Okay, so you are using 5 properties as test cases?
I wouldn't say they're test cases. I was advised not to send out any additional violations because they would more than likely be appealed.
By whom?
By the previous legal counsel, James Callahan.
Do you have anything else relating to generally?
No.
Okay, thank you.
Thank you.
Yeah, sure.
Just a point of clarification, so that we don't maybe have to necessarily deal with this, but as part of your appeal in all of these cases, are you claiming that the number of people in each house were related? Or are you
I-
conceding that they're unrelated? We're just trying to put aside.
No, we're not conceding anything. I don't think the violation, in fact, that's why we're standing here together right now, because I don't think the town issued the violations on any basis. Mr. Green testified that he didn't know on any of the 5 properties whether the students, whether they were students or not, were related or unrelated. They had no basis to issue the violation. So at this time, we would ask the board to consider to approve our appeal and dismiss these violations because the case hasn't been made,
Based on
Mr. Green's testimony.
Are you resting?
No, I'm not. We're asking for this motion to be taken.
So I would advise the board to hear everything. And again, be essentially, if the parties want to have it briefed, and obviously, I've never had a motion in the middle of the case. So I don't know if Mr. Zangari wants to bring up anyone else. And I certainly, wait, can
We
you
don't
let me
stand on
talk to you?
formalities, though.
My
No.
advice would be to hear everything, hear all the legal arguments, and as I've done my entire 31 years, make the decision at the end. Don't make it in the middle. If you want legal briefs, if you want my opinion on all this, maybe you might want my opinion on some of this, or if you want additional legal opinion, wait until everything is heard, and then, certainly you can do whatever you want, but wait until everything is heard, and then make any decision.
Yeah, I'm certainly not ready to make a decision. I haven't prepared enough yet. I think this was just a question that was nagging at us.
And by the way, you guys can ask questions of, if you wish, at
Yes.
any time, Mr. Pimentel or Mr. Green. And you can also ask questions of the attorneys.
And you can also ask questions of.
Of the attorneys, I'm sorry.
We'd like just 5 minutes to talk to our clients and advise them of how we'd like to proceed.
Fine,
Thank you.
you're welcome. Is everyone ready?
So we're back on the record, so the attorneys were going to give closing arguments. However, before they did that, the board, you have the right to ask questions of Mr. Pimentel, Mr. Green, Mr. Zangari, any of the attorneys. They don't have to answer your questions, but you certainly can ask those questions. And then they can give some closing arguments. You may have some questions for me. I may end up telling you that, you know, whatever legal questions may want to be briefed, or I can give those to you in writing, rather than making a decision tonight. I know there were certain, you know, different properties, and we have to hear Rinaldi anyway. So that would be up to you whether you want to continue this to the next date. So that said, do any of you have any questions of any of the attorneys, or Mr. Pimentel or Mr. Green?
I think we have a question. Mr. Green?
Sure.
Please. So, when you went on these inspections, you said that at no time there was no discussion of related versus unrelated when it came to the tenants?
I would always start out by explaining why I was there myself, and that I was following up on a complaint that there's more than 4 unrelated of you. If you were the tenants and you were there, I would say we got a complaint that there's more than 4 living in this house unrelated. Do you all live here? And depending on the circumstances, sometimes they would say, I don't have to talk to you, I know my legal rights, get off the property. Sometimes they would shut the door in my face. This is been a very trying time for us to interact with the tenants and the rental companies. And sometimes the kids would open up and they'd be very frank. Just say, we're here, we don't have a lease, but we paid, or we paid, but we signed the lease, but someone's not on the lease. I never ever had an indication, and in the process of me talking to them, did I say look at them individually and ask them if they were related? Are any of you related? I recall at times saying, are you related, or do any of you related, or I'm here because there's more than 4 and you can't be unrelated like this. But it never ever, if anyone ever was related, they kept it a secret. They never ever said.
Did you ever call, I mean, you were there on the 4 unrelated.
Right.
But did you ask them specifically if they were related or not?
Yeah, at times I would, yes. But did I?
And your answer?
No,
the
because I
answers
don't
you
even,
would get?
I wouldn't even get all of them there. And some of the times I don't even know if I'm talking to the actual kids that live in the house. I would get a first name. Sometimes they wouldn't give me any name. They tell me you don't have to talk to me. I don't have to tell you anything. That's why a lot of the times you'll see the registration numbers and a lot of this paperwork. I'd be standing outside to write down 7 cars parked outside because they wouldn't answer the door. But yet, they want to get an answer as to what I found out, and I'm coming back with not much.
Well, is there anything else that you could have done to, within your authority or powers, which I'm not sure what they are, to verify whether or not these students were related or unrelated, or the people living in these houses?
Frankly, I don't know where we would start. If one of them said, yes, I'm related, that's my cousin. I guess you could try to look back and see if the names are the same, to ask them. I can give you an example. Would that be appropriate?
Certainly.
I have a vanity license plate. I gave it to my daughter. So I went to the state and said, I want to give this to my daughter. Well, I had to prove that she was my daughter. I had to, and her name changed because she got married. So I had to get the marriage certificate, her identification, and go to the registry just to prove that we were related. I assumed that if there's more than 4, 5, 6, 7, however they put on it, living in a house, and that they're related, that that's significant, and that they should have to bring that up, and that would be the exception to the rule. How I would prove that they're unrelated, I'm not sure, but I know how someone could prove that they're related if they wanted to. That would be my answer.
Any other questions of Mr. Green? Thank you, Mr. Green. So, Wayne, how do you enforce this? How, I mean, this,
Kind of like Mr. Green had stated, when we get a complaint, we go out there, and like he said, unless they can show that they are actually related, because he does state why he's there, because of the foreign related ordinance. And as opposed to us showing that they're unrelated, the burden would be on them to show that they're related, so that the purpose of us being there and issuing the violation would be negated at that point. So, you know, in his conversations with the students, he does inform them, all of those that he went to, that he's there specifically because of a unrelated ordinance violation. And when they don't show any proof that they are related, the violation was issued.
Can we have Mr. Green come up one more time?
certainly. Mr. Green?
Yeah,
Can you come up one more, I have a question.
sure.
At the houses that you went to, the properties you went to, did any of them, when you said you were there for, tell me why you said you were there.
I would go identify myself and just basically say, and these are for the houses that I could get, someone would answer the door and they would respond, okay? And they all weren't like that, but some of them were, and I could get there. And I would say, I'm here, we have received a complaint that there's more than 4 of you living here, unrelated.
Let me stop you right there.
Yes.
Did any of them ask what that meant?
It never ever crossed any of their minds.
Okay, so
Okay.
when you said that,
Yes.
continue what you're
Yeah,
going
so
to
I
say.
would say, there's more than 4 unrelated. Now, frequently they would say, well, our realtor said this, or well, if we were related, if someone asked me if we were related, yeah, it never even came up to where that was an issue in any way. All they would have to do is say that they were related. Now, I didn't come out to them and say, there's 6 of you living here. Now, in the process of me saying when I first got there, because there's more than 4 unrelated, you have 6, you're supposed to only have 4 unrelated.
At any time, did any of the people living in the house say, well, we are related, and this is so-and-so? Did they have the opportunity, did they ever tell you they were related?
All right, that's a good question, and I would like to refer back to something that happened several years ago. A man purchased a home for his young teenager, well, purchased it in Narragansett so that his 2 sons could live there. And while they were attending URI, they each lived there, not as renters, because their father owned the house. We got a complaint on the house, so when I went to the house, I asked them, it was a noise complaint, but I asked them about it, and they said, oh, we're both related, and my father owns the house. So there was a way to have that indicated. Outside of that one time, no one's ever mentioned or talked about whether they're related or unrelated. No, it never ever came up in a point of discussion. And I always felt like that they knew that, and that I implied that to them, and that I said that to them in the initial part of it. But I never said to them point blank, looking at them, are you related to anyone here? Are you related to anyone here? It was just, we're here, you can't be more than 4 unrelated. You there are 6 of you, no, that's if they admitted it, sometimes they would back down and say there's 4 of us.
You felt they understood the question you were asking?
Hands down, it was never ever a question as to whether or not related.
So, given the answers that you got, and then with the 2 people that said they were related, so where does that go after you find out they're related?
That was this was several years ago.
Right, so
One
does it
time-
go to, do you report back to Wayne and say, Wayne, hey, you know,
Oh, if one of them, if someone ever said they were related to anybody, even distantly, it would change everything. Because then it would be like, oh, all right, wait a minute, maybe there's 5 here, but
I'm just trying to see where, I mean, so my point was they had an opportunity to tell you if they were related. If they were related, they would have said, yeah, but we're all cousins.
that's fine.
And then you would report back to Wayne
I would have said,
and say, hey, they're saying they're all related. So now where does it go from there? Does Wayne, do you, how do you find out if it's true?
Once I get documentation from Dave, then I would then issue the notice of violation
Okay.
with all that backup and his reports.
So you felt that you were clear on going to that door and they had the opportunity to answer the question?
100%.
Okay.
Yeah, there's not one of these, and this is just, maybe I can't say an opinion, but I'm the one speaking, so, but none of this involves anyone that's related.
Okay.
Because that's a shoo-in, and it would have been brought up, and it would have changed
You
everything.
think they would have said, hey, yeah,
Immediately.
we're related and here's my ID? and-
Immediately.
Okay, so you gave them an opportunity at that time?
Several times.
Okay.
And none of these houses were a one-stop visit. I was multiple times at these houses prior to this, trying to find out who lives there.
Okay, thank you.
Best I could.
Thanks.
So, Mr. Green,
Mr. Green.
I think the issue that some of us, or at least certainly I am struggling with, and I think you can appreciate this since you were a police officer for 28 years, but this violation notice is, at least in my opinion, is like a quasi-criminal charge being made against the appellants who are here. And so, doesn't the municipality bear the burden of proving all of the elements of the violation? And one of those, unfortunately, in this case, at least from the way I'm viewing it, is that the municipality bears the burden of proving that, in each case, that the people living there were unrelated. And it's not, there's no presumption because they didn't answer you or you went up and said something. I mean, that's what I'm struggling with, so if you could respond to that.
Well, correct me if I'm wrong, but I think you just answered your own question. When you said you're assuming the burden is on the town to prove they're unrelated, for me to actually find out there's more than 4 living in a home and to try to prove that the 4, let's say there's 5, because it's a violation, then I'd have to find out on my own if the 5 of them somehow were unrelated, or if they were related. That would, I don't even know if that makes sense.
That's what the ordinance says. The ordinance says in order to issue a violation, they have to be unrelated. So what I'm struggling with is that there's $500 fine for each offense. I don't know if that means every single day or week or whatever, but there's potentially substantial fines involved. It says each violation shall be deemed a separate offense. So I don't know if that's a daily fine, I don't know what it is, but my only concern is that when you get to this stage where there's a hearing as to whether or not there's a violation, do we need to have evidence that they were unrelated? And that may be that every single student needs to be brought in here by the municipality to testify that they were not related. That's what I'm struggling with.
I guess that's your struggle.
Mr. Chairman?
Yes.
So based on your questions, I really do have a couple of follow-ups for Mr. Green. Otherwise, it's not a complete record. Based on your questions. So, Mr. Green, Mr. Zangari showed you in every single file complaints that were submitted to the town do you remember what those complaints were for? Just generally?
Excess, more students renting the home than what was allowed.
Students.
Yes.
In fact, I'm showing you a complaint, which is from my specific client, 11 Walcott Street, dated September 16th, 2022, from Judy Hav, that says, what does that say? More than what?
More than 3 students living in neighborhood homes.
Okay. And
Seamless down here.
so you're aware that there was an ordinance that prohibited more than 3 students from living in a home in Narragansett, right? Are you aware of that?
Temporarily, until it was lifted, yes.
Until it was lifted. And it was lifted after September 16th, 2022, and you got this complaint, right?
Yes.
It was just before all these violations were issued, correct?
That I don't know for sure, but I can enlighten you to something related to that, which is that when it was announced that the town was going to go forward with this, or when it became popular, we received, I'd be guessing, but maybe 40, 50 complaints. And if the complaints were vague, for instance, this is almost a little bit vague. If someone calls and says, I have a complaint, is more than 4 or 5, whatever they say, there's more than should be in the house living there. And they just sign that and put it in. We wouldn't even accept that. We would contact that person and the secretary from the office. And that was part of me instigating that by saying, we can't just go out on somebody, they may not like their neighbor, but they want to complain about it. And they're going to send me out here to go, look, we need times, dates, the amount of cars parked there, how frequently they drive by. So then we started getting them with videos. And we started getting 5, 6, 7 cars parked with registration numbers on the complaints. It made it much easier then.
But on these complaints, on every single one of these 5 complaints, and if we can go through the record again, every single one of them was based on the prior 3-student ordinance that was struck down. It wasn't about unrelated individuals living together. So if Mr. Green went to a door and said, I'm here on the 4 unrelated student ordinance, which again was before the court, and by the way, there was a stay of enforcement at this point, but they were still out there inspecting. Why would students say, why do they have the burden, Mr. Kyle, to say, oh no, we're related? These are kids, first of all. They have the burden to prove. Mr. Green, and I think you recognize that this ordinance is difficult to enforce, but that's what you've got. That is what you've got. You've got a difficult ordinance, but clearly you cannot be issuing violations and then making appellants get up here and try to defend the negative, because that's what we're doing. So I just want to be clear that for the record, because if we have to file briefs, every single one of these complaints are based on the void 3-student ordinance, not on the 4 unrelated ordinance. Except for my clients, 11 Walcott, which is based on a 2-family home. Says nothing about who's living there. So when you talk about probable cause, they've got a problem.
That's incorrect, but
Okay.
So Steve, where does this well, I guess, first of all, I should back up. The Salvatore said that these were based on the 3-person, Mr. Zangari.
It's irrelevant why the complaint is issued. The inspector goes out and determines that there's more than 4. That's what he bases it on. If they said there was 35 unrelated living there in the complaint, and there was only 6, would that make it invalid? No. The fact that the people complain about something that doesn't specifically apply, there's still a complaint, he goes and investigates. He determines what's there, he finds whatever facts and evidence he finds. That doesn't render his findings meaningless because the person who complained didn't know what the proper ordinance was. And it's not, Ms. Salvatore, I would disagree that this is not, you do not need probable cause. This is a civil infraction at best. This is not a criminal matter. So I don't want to confuse the standards. But no, it doesn't render, and it's not like the fruit of the poisonous tree in a criminal case, right? That's not what we have here. This is a civil matter, all right? The fact that they complained about something that is not exact doesn't render his findings any less valid. That would be my answer.
So Steve, where does this law, this ordinance stand today?
So, this ordinance, again, the arguments that Ms. Rocha made were the similar arguments that she made for Judge Taft-Carter, verbatim, that Judge Taft-Carter decided not to issue the temporary restraining order. Based upon that, this ordinance, in my opinion, is still good. Again, as I said at the beginning, we don't have any injunctions, we don't have any court decisions telling us otherwise. Narragansett, obviously, as everyone knows, the unrelated ordinances in 31 cities and towns, we are apparently the test case. But where we stand today is the ordinance is still valid. It hasn't been determined to be invalid. The argument regarding the municipal court, and again, I can certainly have this briefed by Ms. Daniels, that the municipal court issued a decision back in 2017. That argument was made before Judge Taft-Carter. That argument was dismissed at the temporary, at that hearing, based upon a couple of reasons. One is the jurisdiction of the municipal court. The municipal court has limited jurisdiction, and then an intervening case, which was the 3-student case in Providence, which basically said that the Supreme Court said that people do not have, an unlimited ability to live with whomever they want, wherever they want, with however many people they want. And that's kind of a specific finding of that case. So there was an intervening case, but all that, I want to, again, we can certainly brief that, but for your decision, for your review tonight, or an ultimate decision, the ordinance, in my opinion, remains valid.
So, sorry, someone else wants to?
No.
Let me just, I hate to keep beating a dead horse on this, but what I'm trying to get at is, let's just assume for purposes of this that the ordinance is valid. I know it's being challenged in federal court and whatever. How do we get around the fact that before us tonight, there's no evidence other than we just think it's so, that these people were unrelated? How do we reconcile that? There's no evidence that they're unrelated. I mean, are they related? I don't know. I can't say that. Nor can I say they're unrelated.
Correct. I mean, ultimately, the burden of proof is, as I said at the beginning, clear and convincing evidence. You have you have the testimony of the building official and the building inspector, and you have the records. Again, I don't know if you have, do they have leases in there too, or just the rental registration?
No, there were no leases.
No leases. So just, you have the rental registration, you have whatever, you heard testimony, at least on one of them, that the landowner said to Mr. Green that they are unrelated. You can certainly weigh that.
I'm going to object to that because he clarified.
You heard the testimony of Mr. Green, so, and certainly you can obviously base that if ultimately between the direct testimony of the building official, Mr. Green, and the records in the evidence, including the rental registration, et cetera, you know, you ultimately have to make your findings, and that may be different for each matter, depending on what was submitted to you and, you know, ultimately what area.
Steve, a question. When was the 3-student law struck down?
November 9th.
It was October and
November 9th.
November.
And when did the 4 unrelated go into effect?
2016? Chris?
2016.
2016. So that's been, and
No,
just
no,
something
excuse me,
that,
back up. November 9th of what?
this 2022. So just the fact that, and this was another argument, the fact that the ordinance was not enforced is irrelevant.
I understand, I just want to know when did they cross? I'm there. When come when I answer, when I need it.
Mr. Green, could you come up again, please? So in regards to level Walcott, you stated that, you testified that Mr. Preston told you that the students, the people renting the house were unrelated?
As I recall the conversation, he indicated to me, he didn't say none of my renters are unrelated. But he also didn't say they were related. What he said was, and this is going back because part of it was brought up that we were there earlier in the year. The initial complaint involved 11 Walcott because it was a split, a complaint received that it was being rented in two separate houses. So that was earlier. Then when the students were there, and I spoke with the owner, he did indicate to me that he had the right to rent to anybody he wanted to, and then I'm renting to, each one had, I think initially he said each one had a contract, he might have said. And then once he did mention Ian O'Brien, but I don't believe that they were the company that did it. I don't recall.
Excuse me.
I don't recall that, but no, he never indicated any of them were ever related in any way. And he knew that I was calling when we were talking because of the 4 unrelated. So yes, that was in the conversation, we talked. He never said any of them were ever related in any way.
But did he say they were unrelated?
Did he say they were unrelated?
They were
I don't recall if he
not
said-
related?
Yeah, I don't know if he recalled, I don't know if he said they were unrelated.
Thank you, Mr. Green.
That's Mr. People, Ms. Salvador.
Me?
Yes, please. You, when you were interviewing Mr. Green, you mentioned that each of these cases were based on the 3-student rule, not on the 4. Give me a little bit more about that.
So if you look in your exhibits presented by Mr. Zangari, and the complaints that he referred to, that he went over with Mr. Green, in each and every case, those complaints say that the house, the property is in violation of the 3-student ordinance, which is the ordinance that was struck down by the court on November 9th, 2022. So basically what they were doing is taking complaints for the 3-student ordinance and then going to houses on this 4 unrelated ordinance. And then, but again, you know, I mean, Mr. Green just told you again for the umpteenth time that no one ever said that there were unrelated people living there, and that has not been established. And it is a difficult ordinance to enforce. I totally agree with that.
I just want an opportunity to just say a few things at closing when we're there.
Okay, you'll get the chance.
Yeah, thank you.
You're welcome.
Steve, if I may? If I've got a complaint for whatever reason, that's black, not blue, and there's established that you can't have a black bottle, but you can have a blue bottle. Mr. Green or whoever goes out and sees, let me go check on blue bottles. Nope, they don't have a blue bottle, but they have a black bottle, and there's an ordinance against that black bottle. Why can I not enforce that?
You can, if they complained, I'll give you even a better example.
Go for it.
If they complained about 3 students being there, and he's the housing or zoning official, and he went out and the paint was peeling, he could certainly issue a notice of violation for, under the municipal building code of anything. It's whatever the inspector views. And that happens all the time, more with building violations, but it certainly can happen with zoning violations, where they get a complaint on one thing, and it turns out you find an illegal apartment. You know, unpermitted things that weren't obviously in the original complaint, but certainly get cited once the building official or the zoning official go out. Or there can be, I mean, we don't have the resources. Cities and towns, all cities and towns don't have the resources to go looking for these anyway. But if there was, you know, certainly the building official could be driving by, they don't, but and notice some type of violation.
And there's nothing to preclude that.
There's nothing what?
To preclude that, right?
Correct, it's the observation of the building official or the zoning.
Okay, thank you.
So like Keith tonight, I'm struggling with the burden of proof here, and we may need this briefed anyway, but is it the town's position that we've heard sufficient evidence tonight to establish the standard of clear and convincing with respect to the students being unrelated? Or is there a shifting of the burden based on some type of prima facie case?
It's your determination as to whether or not the town's met the burden of clear and convincing evidence, you know that. I would argue that if you're going to take the position that it's the town's burden to prove by clear and convincing evidence these people are unrelated, you're gonna have difficulty upholding the building official's determination. If you determine that the ordinance is there, which means it's public record, the renters, and I mean the renters, I mean the landlords, are supposed to know. These are commercial landlords, these are not residential people. These are business people, right? Renting to other people that appear to be unrelated, all right? They're supposed to know the law, right? There's a little bit of a different standard between a residential dwelling, a person who owns a residence, and a person who's got a commercial building. Right? These are commercial properties used for residential, but they're commercial in nature because they're being rented. These people are supposed to know what the ordinance is. In May of 2016, I think it was, the ordinance was put into effect by the town council, the legislative body for Narragansett, saying you can't have more than 4 unrelated. These people are on notice. I mean, the landowners are on notice that they're supposed to comply. You could very easily make the determination. They have to comply with no more than 4 unrelated. The burden's on them. Right? I'm not going to tell you how to do it, but you could certainly make that determination. Here's the law. It's still a valid ordinance. The burden's on you. You're supposed to know better, commercial landlord. If you take that position, the town's met its burden. If you view it a different way, probably the town hasn't. Fair enough?
Actually, that is the flip side of the coin.
May I respond?
Yes.
Mr. Chairman?
Excuse me, a minute.
Yes.
I'm done. That is the flip side of the coin. fact that there is a law on the books. And obviously, we're a law-abiding society. So, if you want to make the point that these landlords are supposed to follow the letter of the law.
But how do you
Can you
do
make
that?
this step?
How do you do that, right? So,
Well,
our registration,
I've always said that was the
Right.
problem with
Yeah.
an ordinance like this. How do you enforce it?
right, I mean, our registration form does not require them to swear that they are renting, that they are not renting to more than 4.
Right, but there's an ordinance in place that says that you're not to rent to more than 4 units. So does that not, then, does that put the burden on the landlords at that point?
That's why I think we need a brief.
Oh, I
Yeah.
think so too.
I'd like to hear it.
Just, I'm having a hard time getting my head around the fact that it's 2023 and we're taking the position that we're guilty until proven innocent on a violation notice. So, and that's essentially, I don't know what briefing we would do on that issue, because putting aside the fact that the town did not enforce this ordinance after the municipal court decision for 5 years until the 3 student was in place, so apparently everybody's gonna be on notice of it. I think there's a laches issue on that. But putting aside that fact, that we should know the law, there's no evidence in the record that we didn't comply with the law, is the problem. So, you know, I have a big problem saying, well, you're guilty until you're proven innocent with any violation of law. I mean, I think that's a serious problem and a bad path to go down, to say, we're gonna issue this violation because we think you might be in violation, and it's your job to say, to hire a lawyer and say why you're not. I mean, think about where that goes. So, here, there's no evidence that they had when they issued the violation. It's not the landlord's problem that this is an ordinance passed with no ability to enforce it. There could be it could be on the rental registration, a box, I guess. But to now say, oh, we're just gonna hand out let's put it on every house in the entire town, and everybody's gotta come in and say, everybody's gotta come in and defend an appeal. I think that's just not what's before you, and I think that's a dangerous path to go down. That's all, I was gonna put that in my closing, but it keeps coming up, and between that and the whole idea that these people, these tenants are answering the door on a complaint about a 3-student ordinance, and they've got to wave around and say, oh, we're students, we're related, we're not related, we don't know what, we're just gonna volunteer all this information when you're there on a different ordinance is a burden that's on the students that isn't supported by that ordinance. So, or the law, to be honest. So.
Salvatore, you wanted to,
I think Ms. Rocha took care of what I was gonna say.
okay.
I just wanted to make sure she got it. It's hard to do this tag team.
You think your job's difficult? All right, so where are we?
Mr. Chairman, the owner of, is it Wilcox? Walcott,
Walcott.
is he here tonight?
I have no idea.
So, can we have him, ask him if he was aware of the ordinance? Or
You
ever
can
had
ask him.
any knowledge of the ordinance? You get him on the record.
Go ahead.
So I would object to that based on the fact that there's no evidence in the record that when they issued the violation, there was any discussion about unrelated persons. Again, the violations, and I want to be clear, I took that whole probable cause from something that Mr. Kyle said, but similarly, there was no basis to issue the violations in the first place. So you're trying to make a record by asking my client whether his tenants are related or unrelated after the fact, which I assume he's going to deny anyway.
I think Mr. Green stated, Mr. Green, did you state you had a conversation with the owner?
Yes.
And refresh us on that conversation again.
I'm gonna object. It's in the record, it's been, Mr. Green has clarified, it was very clear when the chairman asked him that there was no specific discussion either way. So to keep asking him to try to get the right answer is just not fair.
Well, I think there was a conversation that was,
Yeah, but Joe, I think she's correct on this.
Yeah.
I mean, we've gone over this. I'm comfortable with the information that Mr. Green
Okay.
gave us. I don't know what, what are we allowed to do here, Steve, in terms of,
Well, again, you would either uphold the violation.
no, but
What do you mean by that?
for, can we ask to see copies of leases? Can we?
right.
I mean, you can certainly, we can continue this. You can ask Mr. Zangari or the town, if the town has any additional evidence or information, certainly, you know.
Can we compel the appellants to?
Not in my opinion.
I don't think
No.
so.
No.
Okay.
But if, you know, if there's any other additional information that the town may have, certainly that could be brought in, but you can't compel the.
Okay. No, I thought this is new ground for this board, so I just want to know where we stand.
You've heard a lot tonight.
Oh, yeah,
And-
I'm not ready to make
Yeah,
a
no,
decision.
so obviously, under our statute, once you close the meeting, you have 10 days to decide and, well, make a decision and get a written decision. So my advice would be to keep it open,
Mm-hmm.
to continue it to the next hearing date.
Which is.
Oh, I'm sorry, on the next,
Did you just say within 10
next zoning
days?
board?
No,
No,
if
that's,
we close it.
yeah, only if we close it.
If we
I'm
close
sorry.
I was gonna say, we've had enough zoning board meetings this month.
You have no idea.
I love the job, but no.
Well, it's the benefits.
Benefits.
And we then hear Rinaldi, you never put on anything.
I did not.
Yeah, we then hear Rinaldi at the next meeting, and then if you have any
And
additional
a
questions.
regularly scheduled.
In our regularly scheduled meeting,
That's an appeal.
and then you can, if the parties wish to submit any legal memorandum, they can. If you have any specific questions, you know, again, the basic regarding all the arguments that Ms. Rocha made regarding latches, regarding all that, you know, certainly that was briefed at the Superior Court level by DeSisto law and pretty much dismissed by the judge. So, you know, again, my
I'm
Can I-
gonna object to
You
that
got our
clarification
attention.
because we were there on a temporary restraining order, which for those of you that don't know is a temporary restraining order, then goes to a preliminary injunction to be heard on the merits. So there was nothing decided on the merits so to keep characterizing it as dismissed, that these arguments were dismissed is not true. We did not get to the preliminary injunction. because it was removed to federal court and now we're at the whim of scheduling for federal court. So just want to be clear about that. And the order does say just temporary restraining order.
Okay. Thank you, Mr. Richard.
So, again, continue it, sort it out, hear the other one, and if the parties wish to submit any legal memorandum, they certainly can to you, to the board, in advance of the next meeting.
Okay. Yeah, I'm not ready to make a decision this evening. That's what I don't know if anyone else is. But, yeah, I don't think so. So do you want us to do a continuation of Rinaldi now and then?
Oh, yeah, or you could do
And
all
then we'll-
five. Yeah.
We'll make a motion as far as this meeting goes.
Correct. Despite the global nature of this, we need 5 individual motions. These are 5, I apologize. These are
That's
5
all right.
separate
That's-
cases.
That's
I
fine.
don't think you can globally continue them.
All right, well, right now, Chair, what is our date in May?
May 18th.
May 18th. Chair would entertain a motion to move Rinaldi to a date certain of May 18th.
So moved. Second.
Made and properly seconded. Any discussion? Hearing none, all those in favor?
Aye.
Aye. That motion carries 5-0. All right, as far as what does our agenda look like, May 18th?
You have 4 items on the agenda, Mr. Chairman. 2 are continued, Emma and Ludwig.
Wow.
Yeah. And 2 are new, Gilden and Richards.
So
That I can recall off the top of my head. You have at least 4.
At least 4.
So M is for decision, right?
M is for decision.
Ludwig?
Ludwig is.
Was continued from last Thursday.
Okay.
Mr. Sitter is working on trying to work magic. So, we'll see how
Two
that
new
goes.
ones. Okay.
Mm-hmm.
Do we want to move this, do we want to do a special meeting on this, or do we want to move it to the 18th?
That's,
I
I'm
mean,
here no matter what, so, I mean, that's really, that's Jill and
if we
your
only have
call.
4,
You only have 4 right now, plus 5 is 9.
no, it's-
Yeah. We're all here, Mr. Chairman.
all right. So, Steve, you want this as individuals?
Yeah.
We're gonna leave this meeting open. And so Chair would entertain a motion on BTRI, Secundit Boulevard Investments, move to a date certain of May 18th.
So moved.
Second.
All those in favor?
Aye.
Opposed, that motion carries 5-0. 9 Exeter LLC, also moved to May 18th.
So moved.
Second.
All those in favor?
Aye.
Aye. Motion carries 5-0. East Side LLC, again moved to May 18th.
So moved.
Second.
All those in favor?
Aye.
Aye. Motion passes 5-0. And NITA also moved to the May 18th meeting.
So moved.
Second.
All those in favor?
Aye.
Opposed? That motion carries 5-0. So anyone that would like to provide the board with any additional information, will be
Yeah,
written information, gladly accept it before the May 18th meeting. Other than that, everyone's free to go.
Thank you, Mr.
Thank you.
Chairman.
Thank you.
Andrew.
and there's no
Love those
reports
socks.
from the solicitor or from.
Sake is my favorite part.
No reports from
Dressing
staff
up every
this
day.
evening.
Justin, I just need
Not
to
this
make-
evening,
All
Mr.
right.
Chairman.
Hang on one second.
Entertain a motion to adjourn.
Second.
All those in favor?
Aye.
Opposed? That motion carries 5-0. We are adjourned.